Welcome. We have more than 5 hours of argument time requested, so please ask only for the time that you need, not the time that you wish. We are familiar with the briefs and the records, and if we have additional questions, we will keep asking them. People versus DeGirolamo, appellant. That is submitted. Ustach versus Board of Education. For appellant? And were you requesting any rebuttal time? Respondent? 5, 1, and 5. T-Pool versus ACS is submitted. Riko Alternative versus 5 Stone Green, appellant. Respondent? I'm going to give you 6, 1, and 6. If we have further questions, we will keep asking them. Chen versus City of New York, appellant. Respondent?
Respondent City requests 4 minutes, Your Honor.
Respondent, care for homeless requests 4 minutes.
I'm sorry, how much did the city request?
4 minutes, Your Honor.
6 and 1 and 4 and 4. People versus Gomez, appellant. Respondent. 6, 1, and 6. Jackson versus Bronx Care Health System, appellant. Respondent.
Respondent requests 5.
I feel like there's a theme here. 6, 1, and 5. Deutsche Bank versus HSBC, appellant.
Requests 4 and 4, Your Honor.
Respondent.
Good afternoon, Your Honor. Respondent requests 7.
4, 4, and 7. People versus Kogan, appellant.
Requests 7 and 2, Your Honor.
Respondent.
Respondent requests 7, Your Honor.
6, 1, and 6. Papis versus B&G Holding, appellant.
Appellant, Your Honor, request 8 and 2.
Respondent.
Respondent
5. 6, 1, and 5. And again, for all these cases, we'll keep asking if we have more questions. Velez versus LSG 105 West 28th, appellant.
Appellant, respectfully, with the court's permission, and if respondents agree, I'd like to put it on submission.
Have you discussed it with them?
We did.
Is everybody good with this submission?
I'm here. Oh, I'm sorry. That's fine with me. Okay. Yeah.
Is the court okay with that case being submitted? Does anybody want to ask any questions on that? Velez? No, everyone's good? Okay, it's submitted. Malerba versus New York City Transit Authority, appellant.
For respondent EA Technologies, 4 minutes, please.
Respondent Peter Malerba requests 5 minutes, please.
Does Amnon really need to have argument time? I mean, I looked at your brief. I don't really know what you would add to the argument since you're not really taking a position. I know you felt like you were maligned, but we're not going to be addressing that on.
That's fine, Your Honor.
Do you want to submit?
Yes.
I mean, again, there's nothing really that is pertinent to this appeal.
Nothing about the legal argument, just our factual representation.
Right, which we've read and we're familiar with. Okay, 6, 1, 4, and 5. People versus Truxler, appellant. That is submitted. And CK Opportunities Fund versus Morgan Stanley is submitted. So our first case for argument today will be Ustach versus Board of Education.
Step up.
Good afternoon, Your Honors, Counsel. May it please the court. My name is Corey Morris. I have the pleasure of representing the appellant before you again, Sharon
Can I ask you
Lafia.
something? Why not just answer the complaint and then move for summary judgment in this case?
Your Honors, the legislature decided to make 4 new laws. 2 procedural, 2 substantive. I know you read the briefs. In that law, it allows us to do this. And until the legislator or this
So
court says...
what's the law that allows you to move for a motion to dismiss, a motion for summary judgment before an answer has been served?
CPLR 3212H and CPLR 3211G allows...
Explain why you think they're applicable.
They're applicable because specifically, and the legislative intent talks to this extensively, we don't have to engage in this costly litigation, a deplorable litigation, unfortunately, that has already been resolved. The facts in this case have bore out. The plaintiff, the respondent in this case, has testified for 2 days. He knows what he said. And in fact, we provided him what actually happened. We don't need to go through this again.
All right, but we do have a lot of procedural rules about what evidence can be submitted at what time in support of what motions, and you can't bypass that process.
Well, the process, again, the process wasn't there in 2019. It wasn't there in 2018. But when this court clarified, because remember, we were here before. This
Right,
court,
and we denied the motion to dismiss.
this court,
Well, the court below denied the motion to dismiss.
no, this court affirmed the motion to dismiss. This court said it's dismissed.
Right, but now it's still, I'm sorry, the court below denied the subsequent motion to dismiss.
It was dismissed. It was somewhat revived, but the only order before this court was one of to dismiss all the claims.
What remains of the case?
The only thing there, Your Honor, is retaliation. And this court eloquently stated, right? Teachers cannot discipline school employees. That's the quote from this court. The only thing left is retaliation. And do you know what the claim?
Isn't it aiding and abetting retaliation?
Your Honor, you're right. It's even more limited than that. It's aiding and abetting. We don't really know what it is, but the only thing it surrounds is the allegations that plaintiff respondent was watching nude or semi-nude women while in the special education setting. Reporting behavior like that is protected by the Strategic Litigation Against Public Participation. In fact, that's exactly what SLAPP is about. It's that clients like mine that suffer through...
Right, but your case was commenced before 2020 amendment, so why?
Indeed.
Why would it apply if it was commenced before the 2020 amendments? And we have held conclusively that the anti-SLAPP does not have retroactive application.
Absolutely.
So
Well,
how can you rely on that?
VIP Pet Grooming versus Sproul, S-P-R-U-L-E, 224, Appellate Division 3rd, 78, Penn site 88, a 2024 Second Department decision says, and I quote, 2020 amendments to Civil Rights Law 70A apply prospectively. End
Right,
quote.
but prospectively, I'm sorry, did you say prospectively?
Yeah.
Right, but this case was commenced in 2020. So the amendments were not in place. I mean, it was commenced before 2020.
Yes.
So those amendments were not in place. And since they don't apply retroactively, how are they applying to this case?
The CPLR should apply moving forward. This is
Sorry, we have unambiguously, I'm not sure I'm following your argument. We have unambiguously held that the SLAPP is not to be applied retroactively. And in this case, for it to apply, it would have to be retroactive. So what's your argument that it applies?
Well, Your Honor, there was a SLAPP provision before. The amendments as they apply, the CPLR provision that allows this to move forward.
So your argument is that the previous version of it, but aren't you relying on the expanded definition of public interest in the 2020 amendments to bring this case within the purview of the anti-SLAPP?
Among other things,
You
we
can't rely on it if that would be a retroactive application.
for instance, for attorney's fees, yeah, we can't rely on that. But in terms of the
About
process,
attorney's fees, the city is not representing your client here, right?
no, and for,
Does the record reflect why?
there's a prolonged litigation. I don't think the record here in this case does, but the record before, and I could certainly explain this to Your Honors. The fact of the matter is, there was an allegation by Mr. Ustach, a paraprofessional. They took my client's phone, they searched her phone, as opposed to Mr. Ustach's phone, for all of this wrongdoing that didn't exist. Eventually, in over 8 days of testimony, it came out that a student, not Ms. Lafia, made these allegations. The aiding and abetting retaliation is over. There's conclusive testimony, and I see the
That's
red
why
light.
we suggested the summary judgment. Let's hear from opposing counsel.
Good afternoon. May it please the court. My name is Cleela Arrington, representing plaintiff respondent.
So one of the reasons that we were concerned, and the court was concerned about dealing with this as a summary judgment motion, was that you had indicated that there were documents that you had not seen because the case is in early stages, even though it's been going on for a long time. So what kind of documents do you need to oppose a summary judgment motion here?
Well, as a preliminary matter, in support of his motion, or her motion, apologies, the appellant submitted excerpts from transcripts from a disciplinary hearing at the Department of Education. This was not public speech. In fact, it was so private that when my firm requested the full transcripts via the Freedom of Information law, they were denied.
Were these transcripts of a hearing where your client testified?
Yes, he testified as a witness. He was not a party to this proceeding. In fact, it was a disciplinary proceeding against the appellant defendant.
How does the individual defendant remain in the case? Because the individual defendant, Ms. Lafaya, is not in a supervisory capacity in any way over your client, right? So how does she become embroiled in a retaliation claim? She had no power over his position.
Oh, that is why, as I think Your Honor observed previously, this is an aiding and abetting claim. It was subject to a motion to dismiss, which was granted in lower court in the first instance. We simultaneously appealed that decision and moved for re-argument. We preserved the claim against Ms. Lafaya for aiding and abetting retaliation on re-argument in the lower court and updated this court, mooting that portion of the argument, so it was not actually dismissed in this court.
So you can be liable for aiding and abetting retaliation, even though it's impossible for you to be actually liable for the retaliation. Is that what you're saying?
Yes, Your Honor.
Anything else?
I would like to point out that even had the appellant provided full transcripts, again, this is a proceeding that was private that my client was not a party to. He did not have any representation there. He did not examine any witnesses, nor did his representation.
Do you want us to address the merits, though? Because right now it's primarily a procedural issue, whether this was appropriately brought as a motion to dismiss or as a motion for summary judgment at this stage in the proceeding without having any discovery or an answer filed. Do you want us, would you want us to address the merits of this case in terms of rendering our decision?
No, Your Honor. As far as we are concerned, this was procedurally deficient, as was ruled by the lower court.
Okay, thank you.
Thank you.
Your Honors, Ms. Lafaya commenced a FOIL action in this case. She got the records. She's not
Counsel,
special.
it's limited what you can bring, though, on a motion to dismiss.
Your Honors, we could do this again. We'll file an answer. We'll do a motion for summary judgment. We'll come back here. There was only one order before your court when it dismissed everything. And then the only order before this court was somehow undone by clarification.
But there
Right,
is
but
an
the
aiding
court
and-
did. I'm sorry, go ahead.
there is an aiding and abetting cause of action, even though there couldn't be a retaliation cause of action.
Your Honor, as I sit here today, I have no idea how that can proceed, especially given the nature of these allegations and really the bottom line here, and this court sits in justice and in equity. We now know who made the complaint, and it's not contested. 2 days of testimony, it's a co-defendant. New York City is a co-defendant here. Subpoena the records.
The city human rights law does, correct me if I'm wrong, does permit an aiding and abetting cause of action for retaliation, right? So it is conceivable that there could be this sort of a cause of action, even though the retaliation itself could not possibly be ascribed to Ms. Lafaya.
Your Honor, you're correct, exactly. And you know what? She didn't do it, and she shouldn't be here, and that's why we appealed. I
Thank
thank the
you.
court for its kind consideration. Thank you.
Thank you. Riko Alternative versus Five Stone Green.
Good afternoon. On behalf of appellants, we'd like to address two central issues on appeal. Whether there's any legal precedent to conclude that pursuant to CPLR 321C, an automatic stay is not triggered,
Speak up a little.
where there is continuous representation upon removal of an attorney of record, and whether that conclusion is consistent with the legislative intent of CPLR 321C. The answer is no on both. The law is well settled that an automatic stay is triggered under 321C where the party is involuntarily deprived of counsel by no fault of their own prior to entry of the judgment. But here, in this case, the lower court determined that an automatic stay was not triggered because the appellant's prior attorney of record.
Do you want to address the partnership issue and whether there was or was not a partnership that was representing the party?
There was no law firm
That's what I want you to address.
representing the
Why was there
party.
not a law firm?
The law firm of Kogan and Martirosian that has been referenced at length, it's been clear based upon the affirmation of Mr. Cohen that he did not represent the clients in this case, that he was unaware of what was going on in this case until he.
What about the fact that there was a letterhead that had both their names on it and that the correspondence was being sent out with a letterhead of a firm, of a partnership?
Yes, well, there's no indication that opposing counsel or his client relied upon that letterhead, or else surely upon the death of Mr. Martirosian, opposing counsel
What
would have.
about the fact that the other attorney actually sent out initially a letter responding to an inquiry about the case?
Well, unfortunately, that individual is not here to explain himself. The case law that is being used to support this notion that a continuous representation would not trigger the automatic stay is based upon Cassini and Hall. And actually, those cases, if read properly, support our position, Your Honor. Cassini dealt with a situation where there were two attorneys of record, and one of them was disabled, and an automatic stay was triggered nonetheless. And the reason why? Because there was prejudice as a result. The client was unaware of a cross motion to appoint a receiver in that matter. And in the Hall case, where you had a pro hoc vice attorney and an attorney of record appearing on the case at the same time, and the pro hoc vice attorney died, a automatic stay was not triggered. And why? Because the judgment had been signed and there was simply a ministerial act of entering the judgment at that point. So there was no prejudice. But in this case, it's clear that when Mr. Martirosian died, there was no attorney on the case until I appeared. And there's been a tortured reasoning to try to find that Cohen remained the attorney of record on the case when Mr. Martirosian died. However, that's also inconsistent with the decision itself, where it later on discusses how my clients were somehow responsible for an absence of an attorney. So we have in the decision an inherent inconsistency. On the one hand, the lower court seems to suggest that there's continuous representation. On the other hand, it explicitly acknowledges that there was an absence and clear break in the representation prior to entry of the judgment, Your Honor. So this whole notion of letterhead is beside the point, and the controlling case law on this issue is the Moray case. That's the governing case from the Court of Appeals, Your Honor, and they are primarily focused on two factors that triggers the automatic, two factors regarding the automatic stay. Was the automatic stay triggered? Was the attorney removed involuntarily by no fault of the client's, essentially a force majeure event? And number two, has there been prejudice as a result? And all it requires to lift the automatic stay is for opposing counsel to notify my clients, the appellants, to obtain new counsel. That never happened in this case, Your Honor.
Thank you.
Counsel, Mr. Martirosian, whether it was opposing or making a motion, he, his pleadings had a signature block that referred to the firm, to Marderosian and Cohen. So you have that, and you also have the letterhead, and you also have the email that he sends to plaintiff's counsel, in essence, saying, let me speak to my partner, Mr. Cohen, to find out if we are going to be representing all of the parties in this litigation. So wouldn't that lead a reasonable person to believe that he or she is dealing with a partnership instead of just one individual?
Yes, perhaps. And perhaps my client was equally confused, and that was later clarified in the form of an affidavit by my client and by Mr. Cohen. The actions of Mr. Cohen are minimal in this case. He was only reached out to by my client once opposing counsel had asked if they had obtained new counsel. Now that raises a whole set of other issues as to why opposing counsel is reaching out to my clients in the first place if he wants to later claim that Cohen was continuously representing my clients. I'd like to just bring the court's attention back to the case law. These are very messy facts, but I think the case law helps clarify what's going on here.
I'm going to let you address that in rebuttal as your time is up.
Yes, thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Jacob Albertson from Mitchell Silberberg and on behalf of the respondent, Riko. I think this is, in fact, quite a simple dispute that boils down to two critical questions. The first question was, did appellants remain represented after the death of Mr. Marderosian? And the answer to that question is clearly yes. And to find that answer, the court need only look at the statements of the appellants. On August 18th, 2023, in response to the question, do you have counsel? One of the appellants said, yes, Mr. Marderosian's partner, Stephen Cohen, represents the appellants in this proceeding.
Counsel, what about the fact that there is a lot of evidence to support the fact that there was not a partnership in this case? Cohen's affirmation they didn't share offices, there was no written agreement, they did not have the same contact info. All of that supports the position that there was no partnership, and the only evidence of a partnership is the letterhead without really anything else.
I think there are multiple points, Your Honor, of evidence that there was a partnership, and the only evidence of there not being a partnership is the bare affidavit of Mr. Cohen.
Well, what's the overwhelming evidence that there was a partnership?
Okay, so
'Cause I didn't see. I mean, I think it's not disputed there was no partnership agreement.
well, there was no partnership agreement produced. There was no retainer agreement produced that may shed light on this issue. So that's one thing to sort of set aside. But the evidence that there was a partnership, the letter from Mr. Marderosian on Cohen and Marderosian letterhead with a bunch of locations listed under it. It's an official looking letterhead that says this firm represents the appellants in this case. There was a subsequent email between me and Mr. Marderosian where I asked the question about the representation. He said, let me ask my partner and get back to you, that partner being Stephen Cohen. There was a submission to the court, a handwritten submission by Mr. Marderosian that wrote in Cohen and Marderosian, not just Marderosian. And then there was the actual brief that was submitted, and the signature block said Cohen and Marderosian, counsel for the appellants. Now, given all that information, that's objective evidence that there was a partnership. And as your honors know, the New York ethical rules prohibit an attorney from representing that they're in a partnership with someone when they are in fact not. And the reasoning—
ethical rules prohibit a party who has a counsel from being contacted by a party for the other side.
If counsel—
Sorry, a lawyer for the other side.
Thank you, Your Honor. If a lawyer knows that a party is unrepresented, then of course everyone knows they're prohibited from reaching out directly. At the point I discovered that Mr. Marderosian had passed away, it was when I was trying to figure out, can I get someone to accept service of these information subpoenas? So I reached out to counsel, and I did CC their last known counsel, who had been CC'd on information on a submission from Mr. Marderosian. That was their arbitration counsel. And the only question I asked was, hello, sirs, I'm sorry for the loss of Mr. Marderosian. Please advise whether you have counsel. Now, I don't think that's in violation of the letter or spirit of the rule. Now, the response immediately from Mr. Jones, one of the appellants, was, yes, in fact, we are represented by Mr. Marderosian's partner, Stephen Cohen. Here he is, CC'd here. I subsequently spoke to Mr. Cohen to, again, try to get him to just accept the information subpoenas, service of the information subpoenas, to get enforcement going. It had been some time since the award was granted. And Mr. Cohen told me that he wouldn't be representing them going forward. And that's fine. That's between them. That's none of my business. The point is that after Mr. Martirosyan's 2021 death, up until at least August of 2023, they were represented by the law firm and by their express words by Mr. Cohen.
Do we know who filed the notice of appearance on behalf of the defendants?
Notice of appearance in the court below?
In the court below, yes.
It was Mr. Martirosyan.
Personally, or on behalf of a firm?
I haven't seen his notice of appearance. I don't know if he filed a notice of appearance. I think that his only submission was a letter that he wrote to me that he copied to the court and filed on ECF on the Cohen and Martirosyan letterhead that said this firm represents appellants in this case. So given that, I said that there were two key issues. The first was the factual question, which Judge Maisley, I think, very astutely found. And if you look at Judge Reed's reasoning in the transcript before he recused himself, I think he was also in agreement that there was no real dispute that there was continuous representation by Mr. Cohen, whether or not he was the partner. He remained counsel after the death of Mr. Martirosyan.
But what do we have to prove that? I mean, I understand the confusion here, but what do we have? Mr. Cohen said he was not partners with Mr. Martirosyan and that he wasn't, the attorney at that time. So what do we have to prove that he was?
Your Honor,
What do we have to go on?
I think it's very simple, Your Honor. Page R394 is Mr. Jones's statement that Mr. Cohen represents the appellants in this proceeding. Now, that is a statement.
By one of the defendants?
Yes, with the others copied. And by the way, these are sophisticated individuals. Mr. Jones is an attorney with 40 years of experience, not as a litigator, but clearly a very sophisticated person, saying in the present tense, Mr. Cohen represents us. That's after entry of judgment. I don't think there's any better evidence.
So what about the fact that the CPLR refers to, and if attorney dies, it doesn't refer to if an attorney in a partnership dies. It said if an attorney dies, there's a stay until 30 days after the notice to appoint another attorney has been served on that party. How should we interpret that term attorney?
So thank you, Your Honor. I think that there's 2 points to that. The first is, if you imagine the practical effect of it in this case, the CPLR 321C contemplates that in the event an attorney dies, the opposing attorney is supposed to send a notice to obtain new representation. In this case, I had just literally been told by the appellants themselves, we have representation. It's Mr. Cohen, the partner of Martirosyan. Cohen and Martirosyan is our counsel of record. I would have to say, sir, here's a notice that I do not believe what you just told me, that couldn't be interpreted any other way. I think you're lying or you're mistaken or what. Please get new counsel. I don't think that is...
Okay, so that's, we don't need to get that. That's a different argument than it's a partnership.
So,
Saying
okay,
a new
so-
attorney, you're making a separate new argument, which we'll consider that argument, but I just want to clarify, that's not the same argument, but thank you.
So, right, I think that's the sort of...
Your time's up, but thank you.
Can I just respond to your question about the reason that a partnership is not part of 321C?
Very quickly.
I'm sorry, Your Honor. I think if you look at the Cassini case, it makes quite clear, although it was in dicta because nobody argued that there was continuous representation in that case, they said that the 321C contemplates a situation where there's a solo practitioner, where there's only one counsel. In the case where there's a law firm with multiple attorneys, 321C does not come into play. That's what the Second Circuit noted, and that's what Judge Maisley held.
Thank you.
Thank you.
A few quick points. It has not been revealed to this day when opposing counsel found out about Mr. Martirosyan's death and why he waited until a day after the judgment was entered to reach out to my clients and not Mr. Cohen or any other attorney or any other court for that matter to advise them of his awareness of Mr.
There was a
Martirosyan.
partnership between Cohen and Martirosyan. When Martirosyan passes away, would it be safe to just assume that now the partnership are the attorneys for the entity or the person?
I'm sorry, I didn't...
Would it be safe to work on the proposition that the firm replaces Martirosyan and the firm is now the attorney for the client?
No, Your Honor. Attorneys appear as attorneys of record.
Let's assume there was a partnership here. Does it change anything?
No, Your Honor, because there's no case law on this point. There's been a passing mention in Cassini that perhaps under certain circumstances, there may be a
What
scenario.
you're saying is that even if there was a firm when Martirosian passed away, you could not say that Cohen is now the attorney.
I can't think of any circumstance under the case law or under these facts where you can reasonably argue that Mr. Cohen was on the case. He has stated in an affirmation that he was not and that he was not aware of what was going on. Mr. Lewis said equally that he did not know what was going on until he received notice from Mr. Cohen after speaking with opposing counsel. And the fundamental issue is prejudice. And that is what Murray is primarily concerned with. Has there been prejudice as a result? And it has been revealed that opposing counsel is challenging this whole motion to vacate the judgment to avoid my client from appealing the merits of the final judgment and the underlying decisions. He has not demonstrated any prejudice whatsoever if this motion is vacated. Thank you.
Chen versus City of New York.
May it please the court, Mark Antar, Belkinberg and Goldman LLP for the appellants. The fair share criteria, Appendix A to Title 62 of the Rules of the City of New York, are the rules which guide the siting of homeless shelters in New York City. The city is required to consider all applicable fair share criteria in advance of siting a homeless shelter. And this requirement to meaningfully consider the criteria, and as stated in Article 9, to explain itself in doing so, has the force of law, and violation is grounds for voiding the selection of a homeless shelter site. Now, this is a case where the city failed to comply with the fair share criteria with respect to the proposed shelter, which was Hotel 91 in Chinatown. Most notably, it failed to consider alternative sites, although the respondents failed to consider other criteria as well. And in doing so, the city and the other respondents are pushing to open what would be the 16th homeless shelter in Community District 3, while the neighboring community districts, 1 and 2.
Doesn't the record support, though, that there were alternative sites considered, but that there were a number of criteria that had to come into play to determine whether those would or would not be viable alternative sites under the rules?
It does not, Your Honor. There's not a single actual site that is referenced in the fair share analysis that was provided by the city, and that's a point that we make in our reply briefs. There are tons of statistics. They go on and on with pages and pages about these statistics and numbers about purported sites. They even say that there are 439 sites that were considered. But those 439 sites, if you look at the fair share report, refer to sites that go back to 2017, 4 years before Hotel 91 was even proposed, and they are for any site, for any shelter in any of the 5 boroughs of New York City. They are not actual alternatives to Hotel 91. And even the list of sites that they say were removed from consideration, as we say in our reply briefs.
Were the two facilities in the area that were closing or scheduled to close in the near future, so that to say that, well, there should be a new site replacing those has a certain reasonableness to it?
There's no analysis of those sites in any detail in the fair share analysis. And none was provided in the presentations, the documentation of the presentations that we have to the community board. There's no evidence of any of that consideration. And in addition to the alternative sites, I would add, the city is required to consider the extent in which the neighborhood character would be adversely affected by a concentration of city or non-city facilities. There's nothing at all about the adverse effect of having another shelter in Chinatown when the
Doesn't the issue of the two being closed at the same time come into play into that analysis?
We don't have that information, Your Honor. I don't know where are those sites located. They're not explained. There's no detail provided in the fair share analysis. And more importantly, in the actual section of the fair share analysis that deals with the effects on the community, they say nothing. And this is a sticking point that the court had in the Silver case, which was affirmed by this court, and in the Ocean City residence case, and in the Rebirth of Bergen Street case, where there were the fair share analysis that was submitted by the city in those cases did not consider the fact that there were schools. In Silver, there were 12 schools within a half-mile radius, and that wasn't considered, and that was a real reason why it overturned the selection of the site. Here, there are 7 schools within a half-mile radius. There are places of worship, Chinatown associations within 3 blocks of Hotel 91. These aren't discussed at all. And the failure to actually make these considerations warrants the annulment of the selection. I just want to talk briefly about the motion for discovery that we also made. The court ruled that by the way, a lot of this could have been fleshed out if we had discovery. The court said that, well, you don't need discovery because all the documents are publicly available. That's nonsense. The court lists on page 10 of the record in its order the documents that we're seeking. They include all communications and drafts relating to the FSS. How is that publicly available? We don't have those communications. All procedures which the city follows when drafting a fair share analysis. In other words, are inspections done? Who's responsible to examine these alternative sites?
Shouldn't we be looking, though, at the determination itself to determine whether it is or is not sufficient? As your main argument seems to be that the determination is insufficient because there's not enough detail. So isn't that what we should be looking to determine whether or not we should uphold it, as opposed to further discovery about the underlying data? Either it is or is not sufficient, or it is or not arbitrary and capricious.
Your Honor, our argument is that the determination was not made. It was a fallacy.
Right, but we would look to the determination to decide that. So why do you need discovery, I guess is my question.
Because all there was a conclusion. There were no facts. And the fair share criteria require action. They require that you actually consider alternative sites. They require that you actually consider the effect on the neighborhood. How did they consider the effect on the neighborhood? They told us the number of staff that are going to purportedly be here, which are not supported by anything, and the number of security guards that they say are going to be there, which, by the way, contradicts the presentation that they made in January of 2022 to the board. The board said, and they said in their letter, oh, there's going to be robust security. They're going to have 6 security personnel there at all times. At that time, we hadn't been provided with the fair share analysis, but when we finally got it as a result of the Freedom of Information Act request, we saw they said there's only going to be 3. And most of it's just going to be between 9 and 5 on Monday to Friday.
Thank you. You have time for rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Susan Paulson on behalf of the city respondents.
What about the argument that the analysis is insufficient on its face?
Your Honor, the analysis is more than sufficient on its face, and it does consider specific facts relating to the specific project at issue. It indicates that it examined how many other facilities were within a half-mile radius of the site, which was only 4. It looked at the specific staffing configuration of this facility, which is 3 on weekdays, 4 on weekends, security cameras, 24-hour hotline, and other. It looked at the service-rich environment that would be provided here with an on-site health center and other services provided. And it examined the potential adverse impacts on the community in looking at the various measures that this facility would provide. There's nothing about this that could be applied to some other random facility here. They were looking at the proposal for Hotel 91. They discussed the configuration of the available building, a 7-story hotel building, 38,000 feet, how it was uniquely amenable to conversion for single and double occupancy rooms.
What about the requirement, though, that you have to look at sites in other areas or other locations and the dispersal rates, as opposed to looking at the adequacy or inadequacy of that particular site?
Yes, Your Honor. There is a requirement to consider alternative sites in community districts with a lower density of such facilities. And the city did so here. But if you look at the rule in the record at 1469 to 70, nothing says that it has to be a side-by-side comparison with an address of the alternative site and a date on which it was looked at, which is petitioner's argument here. And what the city does, it's like the open-ended request for proposals for organizations that can run these homeless shelters. Because of the right to shelter, there's an ongoing examination. And the city has, some of it does predate this shelter proposal, but the city is basically constantly looking at potential sites in order to, accommodate this right to shelter mandate. And they listed all of the sites that they have looked at in the past and over the course of time in trying to find available places to open facilities like this to accommodate the unhoused. And here, there is an available facility that is amenable to providing a service-rich environment, accessible to public transportation, and other sites that they examined in this community district and abutting community districts, as Your Honor noted, for a variety of reasons, had to be removed from consideration. Either they were not viable for conversion to a shelter, they were either too close to another or too far from transportation, or they had lost site control. The developer couldn't develop them in that way. So there isn't the type of examination the petitioner would like DHS to have done, but there's nothing in the rules that requires that. What's required is that alternatives are considered, and the alternatives have been here, and that's well documented in the record, that DHS has examined the possibility of citing these in any number of alternative communities, not just the ones abutting, that might have a lower density of such facilities. I would also note, Your Honor, on the record on page 704, that this community district has specifically requested more safe haven shelters to help address the population of unhoused. So the fair share review, here the determination was rationally based. The record demonstrates that DHS gave meaningful consideration to the fair share criteria. With regard to their concern about schools and places of worship and other things, again, the fair share criteria do not require magic words. And they looked at the fact that it's in a neighborhood that has commercial and residential, that has parks and has playgrounds, and they considered the environment of the neighborhood. They didn't enumerate the number of schools nearby. They did not enumerate the houses of worship, but that is not required. What is required is that they consider the criteria in a meaningful way and reach a determination that's rationally based. And they did so here, and this court should affirm.
Thank you.
Thank you.
Good afternoon, Your Honors. Andrew Akron of Silverman, Shin & Schneider on behalf of respondents, Care for the Homeless and CFH 91 East Broadway Housing Development Fund Corporation. We join in the city respondents' argument that the fair share analysis was properly performed in this matter. However, I would like to focus on the pending motion to dismiss this appeal for mootness. Irregardless of the fact that the appeal is devoid of merit, the project has been ongoing and continuing since the denial of the petitioner's application for a preliminary injunction in March of 2023. At no time did the petitioner seek a stay or a TRO from this court until after respondents made a motion to dismiss in November of...
Did your facility open?
It is not open yet. However...
Isn't it supposed to open in December of 2023?
It was a little bit delayed because of this litigation. It was supposed to open in December of 2024. However, there is some temporary certificate of occupancy work that needs to be finished, less than $100,000 worth of work on a $40 million project. The work is expected to be completed in the very near future, with the site opening in the very near future, but 98% of the work to be performed on this project is already completed. The fact that petitioner appellants did not seek a stay from this court and allowed the project to continue for 20 months and achieve 98% completion, as this court has noted, means that it has been waived. The appeal is now moot. The work that has been performed cannot be undone without undue hardship upon the respondents, given that the respondents are contractually obligated to operate the safe haven shelter, the accumulation of the loan amounts, and the fact that $9 million were expended since the time of the denial of the preliminary injunction before the lower court. It would not be a project that could be very easily repurposed. And that's the bar that this court has set. Whether or not the respondents would suffer undue hardship because the appellant petitioners in this case sat on their hands and just waited. Did not affirmatively seek any relief from this court to prevent the completion of construction or the continuation of construction. And this court has time and again said where a petitioner, appellant, does that and waits, and construction completes and it continues rather, and achieves a substantial completion, whether that's 75%, whether that's 98%, as in this case, the petitioner has lost its appeal for that very reason.
Thank you.
Thank you.
Thank you. Very quickly, Your Honor. On the issue of mootness, the project is ongoing. At no point during the litigation was completion shown to be imminent. The 98.6 figure, there's no proof of that in the record. It refers to the percentage of the loan that was allegedly drawn down. There's no proof that the construction is that far along or was.
So after Judge Ali denied the preliminary injunction in Supreme Court, that was in March 2023.
Correct.
And then you filed your notice of appeal. Did you ever make, I didn't see it, but maybe I missed it. Did you make any applications here in the appellate division to stay the procedures, the project during that period of time?
We didn't, Your Honor, and there's
So it's been like 2 years.
There's a very good reason for that. The project was not ongoing. The work was sitting idly by, as our clients testified in the record in this case. There was no, as counsel said, no temporary certificate of occupancy. They never even applied for a temporary certificate of occupancy. They weren't doing anything on the project. There were no exigent circumstances that would warrant such an application.
Thank you.
Your Honor, may I just have one more?
No, your time's up. Thank you. People versus Gomez.
Good afternoon, Your Honors. My name is Frances Weil, and I'm here on behalf of Heriberto Gomez. Mr. Gomez was convicted after a jury trial and sentenced to the mandatory minimum of 16 years to life and has already served over 10 years for taking personal items and packages from lobbies and storage basements of apartment buildings. Several errors occurred throughout trial that warrant reversal today. In my time today, I would really like to focus on point 1 of the brief, which addresses the violation of Mr. Gomez's right to be present. It is uncontested here that there was a conversation in Mr. Gomez's absence about the insufficiency of evidence to support an intoxication charge on the very same morning and shortly before he waived his right to testify.
Let me ask you, because the law clearly makes a distinction between being present for purely legal discussion versus a more of a factual discussion where the defendant could have some real input in what's being discussed. Why wasn't what was occurring at what was clearly a preliminary charge conference where nothing was actually being decided, why wasn't that discussion a legal one, which is whether a reasonable view of the evidence would support an intoxication charge? They weren't talking about, they were talking about, what the legal analysis should be.
Right, there certainly was a legal component to that conversation. However, it implicated Mr. Gomez's peculiar personal factual knowledge of his intoxication at the time of those offenses.
Weren't they only talking about what evidence was presented at the trial, which had already been presented, and whether the evidence that was presented, not what evidence could be presented, but what already was presented was legally sufficient, which is really a legal determination.
Yes, but it implicated his right to defend and implicated his ability to testify to fill in those factual gaps, because it actually, with specificity, highlighted the gaps in the testimony and evidence in the record.
But counsel,
and even the process, oh, sorry.
Didn't he have an opportunity to speak to his attorney afterwards?
Yes, he did. And I think, the Court of Appeals opinion in People v. Sharp addresses that concern right head on, in that counsel does not have the ability to waive Mr. Gomez's right to be present, and his actions following the conversation do not indicate or are not relevant to Mr. Gomez's right to be
And wasn't that conversation had again after Mr. Gomez was present? Didn't the court have a charge conference where the intoxication defense was discussed?
Right. So I think, to really bring out the inadequacy of what the summary that occurred when Mr. Gomez immediately returned from being absent, the court can compare the conversation on page 501, where he had just returned before his right to, he waived his right to testify, with the formal charge conference that occurred on page 546 during the formal charge conference. There you can really see the difference in that conversation. In his immediate return, the court merely stated in a conclusory way that the prosecution had argued that there was inadequate evidence in the record to support the charge. In the formal charge conference later, you can see the court's concern for actually having the prosecution's argument be repeated to Mr. Gomez. And again, that is not relevant to the argument we're making, in the fact that it happened after his waiver to testify. But the difference, I think, is illuminating.
You're saying he could have had some real input somehow at this informal charge conference. Are you arguing that he might have decided, based on what happened at the informal charge conference, that he would then testify? Is that your argument?
Certainly, it impacted his decision. It was information that he could have used or should have had when he was making that calculus to testify. And in my brief time left, I do just kind of want to emphasize to the court, to bring life to this, about how kind of extraordinary even having this conversation in his absence really was. Every day, attorneys and judges and prosecutors wait for defendants to be brought up into the courtroom before the clerks or court officers will even call this case into the record. And oftentimes that's just for picking a new date or a routine adjournment. Here, this was mid-trial on the day that Mr. Gomez was waiving his right to testify, perhaps, or maybe not. And he was facing a minimum of 16 years to life in this trial. He should have had every single piece of information that the parties discussed that implicated his knowledge of the offenses and what had occurred on that day, and his ability, and implicated his ability to defend. So we don't have to show, of course, because the harm was inherent, that Mr. Gomez would have testified, but this certainly was information that he could have used to know exactly what the prosecution's arguments were about the inadequacy.
That counsel is, that defendants are present at all instances, but there's clearly a rule that sometimes the defendant has to be present and sometimes the defendant doesn't have to be present. And I don't know, somehow you seem you were suggesting the defendant always has to be present or is always present, which is clearly not the case. So the only thing I've heard you argue is that he might have changed his mind about testifying. Is there anything you're arguing he would have actually added factually from his own knowledge that would have influenced the determination?
Certainly, and he could have testified as to what had happened that day in terms of what he had consumed and built the factual predicate required to warrant the intoxication instruction. But the case law is clear that it does not come down to just whether this information would impact that particular proceeding. The fundamental principle underlying all of these decisions is that this impacted or implicated his ability to defend against the charges. And here, where we're talking about intoxication, and Mr. Gomez had that knowledge, the prosecution concedes as much by saying that the only way to fill that gap would be for Mr. Gomez to testify.
Thank you.
Okay, thank you.
Time rebuttal.
Your Honors, and may it please the court, Anna Notchik for the people. Defendant's conviction for 7 counts of second-degree burglary and his resulting sentence should stand. Turning first to the right to be present issue, the preliminary charge conference was a purely legal discussion and was not a material stage of trial that defendant had the right to be present at.
What about the argument that he might have decided, based on what happened at that conversation, that he wanted to testify as opposed to waive his right to testify?
Well, Your Honor, he was fully aware of what happened at that conversation. He was aware that the people had argued that there was insufficient evidence in the record to support such a charge. He could make an informed decision based on that anyway, my apologies, anyway, the only way to add additional facts was for him to testify. Additionally, this preliminary charge conference was summarized with in defendant's presence right after it took place. And he was present for the formal charge conference, which occurred later when the full merits of the arguments were repeated. So even if he should have been present at the preliminary charge conference, any error was cured by his presence at the
Had he
later.
already given up his right, though, to testify at that point?
He had, but he had not given up his right to testify when the court summarized that conversation on the record right after it took place. That was before he gave up his right to testify. But also, defendant knew that the court had not actually decided this issue when he chose not to testify. Turning to the argument that there was no reasonable view of the evidence that defendant had committed burglaries of non-dwellings in some way, defendant was not entitled to the lesser included offense of third-degree burglary or the expanded definition of dwelling because it did not apply to defendant's case where he repeatedly...
Was there any evidence that the defendants offered during the discussion as to why they thought that the expanded definition would be appropriate in this case? I mean, did they give any evidence, like based on, this was said, this was testified to, and as a result of that, we could use the dwelling expanded definition?
It was very limited, just that because of where the actual incidents took place, that this would be warranted. But in that same discussion, the judge asked, well, there's no dispute that these all occurred at some point in lobbies, and the attorney said yes. So that is enough to show that
just couldn't fit into that expanded definition.
Exactly, Your Honor. And just briefly, defendant waived any claim that a jury was entitled to resolve the tolling issue by failing to object to the predicate felony statement on that ground. As this court recently held in Stanton, an attorney can also waive that by acknowledging on the record that there's no issues, and that's exactly what happened here. And if there are no further questions, we ask that you affirm. Thank you.
Thank you.
And Your Honors, I just want to clarify, because I believe that there was a statement that I was saying, arguing that every proceeding there would be a right to be present. And I want to clarify that the formal charge conference on page 546, where if that had been the only thing that had occurred, there may not be an issue here, and we acknowledge that. What we're worried about here is the timing of this conversation and that it happened before Mr. Gomez's presentation of evidence. So a charge conference after the close of evidence is not a relevant comparison, because what we're arguing specifically here is that this happened right before Mr. Gomez made these critical decisions. And that, so we're really focused on that summary that occurred on page 501, where our argument is that the court omitted critical information in that summary. The parties...
What about counsel's statement that the defendant was aware that the court had not yet decided this issue, and still he decided not to testify, that he decided first and the judge had not yet made an ultimate decision? Is that correct with the timing, and how does that fit into your argument?
Yes, correct that there was no decision made. However, I think also in Court of Appeals' recent decision in Sharp, it makes clear that the decision is not the relevant timing or the point that needs to be made. It's more about whether the timing of it and whether there's an impacts the opportunity to defend against the charges. And in that conversation, critical information was left out about the specifics of what the gaps in the testimony actually were and why the statement that Mr. Gomez was strung out in the interrogation video was not sufficient. And you see that later when the court...
Isn't this information that his attorney could have provided to him? Did he need to hear from the court?
because the conversation occurred in his absence, he had a right to be present and to have a complete contemporaneous record. And the court, in the initial summary immediately upon his return, did not ask the parties to repeat their arguments, where you see that the court later does that on page 546. You see that it's repeated in much more specific detail, where the court actually enforces the attorneys to remake their arguments and even asks the prosecutor to specifically use the language of strung out from the interrogation video. Thank you very much.
Jackson versus Bronx Care Health System.
Good afternoon. May it please the court. Megan Lawless, counsel for the defendant appellant Bronx Care Health System. This case concerns application of New York's COVID-19 immunity statute, the EDTPA, at a time when hospitals in New York continue to deal with the challenges presented by the COVID-19 pandemic. The plaintiff, Tanya Jackson, was a COVID-19 positive patient who was being actively treated at Bronx Care for the virus when she allegedly fell and fractured her ankle after she walked to the bathroom unassisted. Now, Ms. Jackson was—
Let me ask you a specific question, because we are familiar with the case. The relevant statute requires a showing that the treatment of the individual is impacted by the healthcare facility's decisions or activities in response to or as a result of the COVID-19 outbreak. So it's not just that they went there for COVID-19 treatment, there's another step here. And I guess my question is exactly how the hospital satisfied, because this was in a very strange procedural context. It was in a motion to dismiss based on affirmative defense, so you didn't really get to produce evidence in the normal way or have any discovery. How do you conclusively establish that all of plaintiff's treatment was impacted by COVID-19?
Yes, Your Honor. So
specifically, if you could include the walker, since that really doesn't have anything to do with COVID-19.
So yes, Your Honor. So this court held in Hassan versus Terrace Acquisitions, the Second Department and the Third Department have also dismissed EDTPA claims at the pleading stage, where the evidence submitted conclusively established the requisite impact under the statute. Now, in this case, the plaintiff was being actively treated for COVID-19 at the time she fell. The affidavits, the certified hospital chart, and the COVID-19 protocols that were submitted in support of dismissal speak to staffing changes at the time, an influx of COVID-19 patients. And again, the treatment at issue in this case is assistance with ambulation. And the evidence before the lower court showed how specifically this patient, during her admission, how what was going on at the hospital and on the floor she was admitted, how the ability to timely respond to her requests for bathroom assistance, that was specifically impacted.
Right, but she says that she should have gotten a walker when she arrived, and if she had gotten a walker, then presumably she wouldn't have needed as much assistance, and that was never provided by her. And so where's the allegation that, which I don't think there's any allegations about the walker, but where's the allegation that something about the COVID-19 situation prevented them from providing her with access to a walker?
So I submit it's not the COVID-19 situation. It was this patient's COVID-19 infection that impacted the specific decision not to give her a walker. If you look at the fall prevention—
She shouldn't have a walker because she's got COVID-19?
No, she had a walker prior to, because she had a history of MS. And so prior to her COVID-19 infection, she used a walker. And at that point, she said it was in her the medical record. She recounted to the ED staff. She was independent with her ADLs. But when she was brought into the hospital by ambulance, she had zero strength in her right leg and reduced strength in her left. She said to the ED providers, quote, "I cannot walk." When she was examined, she could not move her right leg at all. So the fall preventions that were put in place were to assist the plaintiff with ambulation at all times. The medical records document how she was told, do not walk unassisted.
So even if she had a walker, you're saying, that wouldn't have resolved the problem because she wouldn't have been able to use that on her own?
I think it would have been irresponsible to give her a walker because, again, the fall preventions that were put in place specifically said to assist her with toileting, assist her with ambulation. So I
Why
think
shouldn't
that,
they not- let's say we assume you're right about the Walker issue. Why shouldn't there at least be some discovery about the issue of exactly what was going on at the hospital, what staffing was present, and what ability or what effect COVID-19 did or did not have on their ability to provide services to her, such as coming to assist her and going to the bathroom?
well,
This is a motion to dismiss. It's not a summary judgment motion.
no, I understand, Your Honor, and I think that the situation in this case is much different than in Holder. And I understand the court's decision in Holder. It was a non-COVID patient, and the care at issue was not shown at the pleading stage to have been impacted. And I think that that case is specific to the.
If you have staffing issues as a result of COVID, how do we resolve that issue on a pleading motion?
Well, it's not just, it's not singular to the staffing issues, it's the whole picture. Again, this was,
Who has that information about the picture?
well, the medical records, I think, document what happened. I think also, I understand that there are affidavits in this case, so the argument is that shouldn't those individuals be deposed? But
There are also allegations here, are there not, that she had to wait an hour to have someone come to help her to get to the bathroom? Right, so your answer to that presumably will be, well, it's COVID and we had staffing issues, but how do we, on a pleading motion, resolve that staffing issue question?
well, in terms of the allegation that they didn't come quickly enough, and is that negligence? With respect to the EDTPA, it doesn't matter. You assume negligence because this is an immunity statute. So all you're looking at is the criteria under the statute.
You have to show impact. You have
Correct.
to show that it was impacted, and part of impact is the staff, that brings in the staffing issue. Because how do you show that COVID impacted the treatment without showing that as a result of COVID, there wasn't enough staff? That would be the only reason that COVID would impact it.
Correct, but it's not just staff, Your Honor. It's the isolation and,
Right, but helping her go to the bathroom is staff. She's saying that no one came to help her go to the bathroom, and that's why she got up. That's staffing.
correct, but it's
Maybe it took more time because of the masking and everything, but that seems like an
But that
intensely
is-
factual question.
But that's the question, though. It took more time. So again, I don't think plaintiff has identified truly anything that discovery would bring out
Okay,
that
let's
would
hear-
negate impact.
Let's hear from opposing counsel and hear what his arguments are about that.
Good afternoon, Your Honors. I'm Stephen Sarshik, attorney for plaintiff respondent. Just very briefly, this statute was amended, and the Holder case was even before it was amended. So when it was amended for a reason. The legislature felt that it was too broad, and when they changed the language, it wasn't just now impacted, because when they changed the language, there were two additional things that you had to approve under the amended statute. That the diagnosis or treatment related to COVID-19 specifically, and the assessment or care relates to COVID-19. So it wasn't just the admission or the impacted. The specific care or lack of care in this case had to be related to COVID-19, and that's not what happened here. And if I could just use an example with two different plaintiffs. One plaintiff is admitted into the hospital with COVID, and she didn't get the proper medication or wasn't given a lung machine to breathe properly and dies. That patient's care was impacted by COVID and related to COVID. But what happens to a patient that's admitted to the hospital with COVID and is lying in bed, dozing off, and a staff member comes in and trips over a wire and a light fixture comes down and hits them, and now they have brain injuries? That has nothing to do with COVID.
Counsel, that's not this case.
Right, that has
Case,
nothing to
there
do
is
with
some
COVID.
relation. She was there clearly for the treatment of COVID, and they are clearly making allegations and submitting evidence that her treatment was impacted to some degree by the fact that she had COVID and that the COVID pandemic was going on at that time. So to talk about something falling on someone's head really doesn't seem applicable to the situation we're dealing with.
Well, just to relate to what you said specifically, Your Honor, it was supposed to be impacted, but there's no proof as to what was happening that week or that night. All their evidence,
Why is that
quote,
required-
evidence
why is
is
that
what they
required,
planned
though?
to do, not what they actually did. We don't know how many nurses were there that night because they don't want to tell us. They might have that information. Why didn't they disclose it? Instead, they disclose what their initial plans were once COVID hit. They don't tell us how many nurses were on duty or other aides on duty. They do tell us the number of beds occupied, and we find out they weren't that crowded.
Are you required to accept whatever representations they make about staffing, about the operations of the hospital?
No, we're not required to, but they didn't even try. And that's the point I'm trying to make, that if they have to prove something conclusively, they didn't even make an attempt here to show that it was impacted by COVID that particular time when she suffered her injuries.
Let me ask you specifically about the walker, since that does seem to be one of the issues percolating in this case. What about their argument that she came in saying she couldn't walk at all, she had no strength in her leg, and that was the basis for the determination not to provide her for a walker as opposed to lack of resources or anything else?
At best, what they're arguing is a question of fact, and this isn't even summary judgment. This is a motion to dismiss. In the lower court, we submitted an affidavit from the plaintiff who said that she was never able to walk on her own before COVID, for years before COVID. Attached to her affidavit was a picture of her walker, the type of walker she used, and how that she was unable to proceed and get around without that walker. So for them to say that COVID was the reason that she needed a walker, there's no basis for that. Certainly at this early part of the case, it's one of the reasons there should be more discovery, and they can ask her questions. But we did submit in the lower court that affidavit where she explains her history and the problems that she had.
Thank you.
Thank you.
Just quickly, I think there are situations when the EDTPA should be applied at the pleading stage. And I
And
think
why didn't the legislature just provide a new provision in 3211 like G or H that afforded an expedited pre-answer method to dealing with this, as opposed to turning these 3211 motions into quasi-summary judgment motions?
I'm sorry, Your Honor, I can't answer that. I can just look at the facts of this case, similar to the facts of Hassan, similar to Mira and Martinez in the Second Department and Whitehead in the Third Department, where all those courts, including this court, dismissed at the pleading stage when the evidence before the court conclusively demonstrated the criteria under the statute. And again, I think with a COVID-19 patient, the impact is more self-evident. Again, you are treating a patient for COVID-19. Your response to the pandemic is linked to your treatment of that patient. The impact is self-evident. I think it's different in Holder. You had a non-COVID patient. I think the circumstances under that case where you had a neurological claim and you had neuroattendings, where was the impact? I understand that. But here I think it's very different. You have a COVID patient being actively treated at the time of her fall. The response to the pandemic impacted her treatment. She was there for COVID. And there are trial court decisions that have dismissed these types of cases. Judge Appellate in the Bronx, I'm sorry, New York County, Kings County,
We're
all
familiar with cases.
Yes, they're cited in the brief. But I think this is the type of situation that it's important. I don't think the statute should be diluted, and I think it's important to be enforced.
Thank you.
For potential future emergencies. Thank you.
Deutsche Bank versus HSBC.
Good afternoon, Your Honors. Henninger Bullock, may it please the court. Your Honors, just 8 weeks ago in U.S. Bank versus Equifirst, this court decided the central question presented on this appeal.
And you want us to follow that decision?
Well, Your Honors, I think not only should you, I think for practical purposes, you have to. This is exactly the same case. They were briefed as one motion to dismiss in the trial court. They were argued as one motion to dismiss in the trial court. They have identical repurchase protocol provisions.
So the language in Equifirst is the same as the language in our case, as opposed to what our colleagues found was ambiguous in the LDIR case.
Correct, Your Honor, but for a number of days in terms of how the provisions work. The notice provision is the same. The repurchase, the cure substitution repurchase obligation is the same. There is no ambiguity here whatsoever. And this court in Equifirst addressed that very question, Your Honor, rejected the ambiguity point and said, and I quote, defendant had a repurchase obligation under the mortgage loan purchase agreement, therefore the claims should have been dismissed against it. This is the exact same case.
There's absolutely no question in this case that this defendant was subject to an unambiguous notice obligation.
That's our contention, Your Honor. Absolutely, yes. No, it is not at all ambiguous.
Okay. Thank you.
Good afternoon, Your Honors. May it please the court. Zachary Rosenbaum, Cobre and Kim for the plaintiff respondent. I'll start by disagreeing. Not only with...
I only hope.
I have a delicate task today. But there are two different agreements in play here. And one is fundamentally different than the one that this court assessed just several months ago in Equifirst, and that's the one applying to HSBC Bank as defendant. The agreement applying to Decision 1 as defendant, I will concede, is substantially similar or perhaps even substantially the same as the one in Equifirst, and I'll get to that second. But as to HSBC Bank, which was the sponsor of this securitization, and therefore first the recipient of representations and then the passer along of representations, its obligation for repurchase was limited very specifically only to representations that were what are called gap. In other words, representations that weren't also made by one of the other transaction participants. The vast majority of the representations that were breached here, as alleged, were non-gap. And why is that distinction very important? Because the HSBC Bank's notice obligation was as to all of its representations, whether gap or non-gap. But its repurchase obligation was only as to gap. I know I'm saying gap and non-gap a lot, but I'll try to unpack it because I think Justice Reed below said it better than I probably could. He observed on page 6 of 9 of the trial court decision, HSBC Bank agreed to provide notice upon discovery of the breach of any of its representations, parentheses, gap or non-gap, but the sole remedies provided or cure or repurchase on gap representations for which HSBC Bank is responsible. Justice Reed continued, while HSBC Bank's repurchase obligation extends only to its, quote, gap R&Ws, and the sole remedies available against HSBC Bank for breach of any of those, quote, unquote, gap R&Ws are cure and repurchase of a breaching loan, and this is the important part, HSBC Bank's notification obligations by its express language is not so limited. So what does all that mean? It means that as to HSBC Bank, this case is much more like the Bank of New York Mellon facts and the Malerba Part 60 facts. In each of those, in Bank of New York Mellon, it was a servicer who had no repurchase obligation, and this court recently relied on that decision in the Equifirst case, found that claims against that defendant can and should proceed for failure to notify. And same in matter of Part 60, although it was a I think a securities administrator, not a servicer. So short story is, as to HSBC Bank, there is a, not to overuse the term, but there is a wide gap between this case and the recent Equifirst decision. And that, I think, standing alone, dictates that the trial court should be affirmed as the HSBC Bank. As to as to Decision 1, as I noted, the provisions are substantially similar or perhaps even the same. So there is really no gap or daylight between the two. So as I noted, I have a delicate task of trying to convince this panel that just months ago, members of this panel got it wrong, frankly. Let me explain how I'll try.
Well, it's also a question whether Equifirst recognizes that the distinctions which had been drawn before perhaps were not the best idea.
Excuse me, I didn't hear the last
That
part.
perhaps was not the best idea. The distinctions, thereby allowing these causes of action to continue, that the differentiations that were drawn in previous precedents maybe don't stand up so well. And Equifirst represents an indication not to continue making those distinctions for the failure to notify cause of action.
Understood. And I think as a fundament of New York law, if there is an independent obligation, then it can be independently breached. And the prior decisions, starting with Nomura 1, were that the notification obligation is independent of the remedy, as Ace concluded, of repurchase. And I think that interpretation can and should stand, and all of this comes back to basic contract interpretation. And let me, I know my time is almost up, but I'll try to explain why, starting with the plain language and then looking at what Ace actually did, warrants that result. I've studied it. The plain language as to Decision 1, and Equifirst for that matter, has a paragraph that requires notice upon discovery, in this case, by Decision 1 of a breach of representation and warranty. In a separate paragraph, immediately below, is the repurchase, the beginning of the repurchase protocol. But interestingly, when you read the beginning of the repurchase protocol, it isn't triggered by a notice from Decision 1 to the trustee. It is simply triggered by discovery by decision. There's no indication that the repurchase protocol gets triggered when Decision 1 fulfills its notice obligation to the trustee. It simply gets triggered when Decision 1 discovers the breach or when the trustee notifies Decision 1. So I think when you look at the way these highly sophisticated parties constructed their contract, their intention was to have an independent obligation of notice, and separate from that, a repurchase protocol. So I do think that as a matter of contract interpretation, which is what this really rides on, there is a separate obligation, and if there is a separate obligation, there has to be a remedy.
Thank you.
Your Honors, if I could just make two quick points.
Can I ask you to address his specific claim that not all of the breaches had a repurchase obligation associated with them?
That is a distinction, frankly, without a difference, that has fallen out of the case at the motion to desist phase, and in fact was not an argument made in opposition to our brief. There is an argument to be made about the fact that there are non-GAAP requirements in the MLPA. The trustees' claims aren't under that agreement anymore. They're under the PSA. And in that respect, HSBC Bank, just like Decision 1, has a notice obligation as to all breaches of reps and warranties.
There's no basis for his argument that some of the claims that are still alive in this case do not involve a repurchase obligation ultimately.
Looking at the, frankly, at the express language of the agreement, it couldn't be clearer. HSBC Bank has an obligation, as do all parties to the transaction, by the way, whenever they discover, trustee, certificate holders, securities administrator, anyone, to give notice. That triggers the protocol. And once you get to the end of the protocol, it says the remedies are repurchase, substitution, or cure. Are there instances in which HSBC Bank would have no obligation to do that? Yes. But nonetheless, the express language of the sole remedy protocol, if we're to somehow say that HSBC Bank is different here, makes clear that the only remedy the trustee can ever have as against HSBC Bank, and the language isn't limited like the other cases they cite, the only remedy are those three items. If they bargained away For certain breaches, even that protocol, that was their choice as part of a negotiated contract. So there is not a distinction here.
You're saying the distinction made by the trial court is not a distinction, which is a real one.
I think the distinction the trial court made got it in the wrong and reverse direction. It focused on the PSA issue or the MLPA issue, which isn't in the case. Here, the language is as broad as can possibly be and rules out any obligation. The other point that I would like just to make very quickly, which I believe goes to the argument that there was somehow an intention by the parties in all of these transactions, and I want to point that out, not just this case, but all of these transactions, for the notice obligation to give rise to an independent cause of action. The Court of Appeals has spoken on that issue very clearly. It did so in each of its DLJ decisions. It did so with respect to ACE, AMBAC, Nomura 2, et cetera. And DLJ 2 and DLJ 1, I think, are very important. They specifically say that that notice provision does not give rise to an independent substantive cause of action. It's simply a condition precedent that is derivative of the breach of representation and warranty and that triggers the repurchase protocol. What the trustee respectfully is advocating here is for you to apply the same language that applies to all parties in two different ways depending on who the party is without any difference in provision.
So you're saying we need to be, not that this is a case for, but that we need to be going further.
I just think what he is saying is if it's a substantive obligation, then it is for everyone. But the Court of Appeals has already said it's not, and therefore you can't create it as one now.
Okay, thank you.
Thank you, Your Honor.
People versus Kogans.
Good afternoon, Your Honors. Samuel Barr of the Legal Aid Society for Appellant Tony Kogan. The trial court here allowed 7 people who were not witnesses to a fight to testify about what they saw on a, quote, okay quality surveillance video a year and a half earlier. This court's decision in People v. Cyrus squarely rejected this sort of testimony. It said that such testimony by people who merely viewed a surveillance video and did not witness a fight would be inadmissible on the people's direct case. The only precedent that my adversary cites is from this court is People v. Tanner, a 2009 case. That decision contained no significant reasoning. It did reject a best evidence claim. If you look at the People's brief underlying that case, which we cite in our reply, you'll see.
Doesn't the best evidence claim have to do with what evidence is available? Clearly, if we had the video surveillance footage, then you couldn't have anyone come in and testify about the video. But if there is no video surveillance footage, why would the best evidence rule prohibit other people from coming in to testify since we don't have that best evidence anymore?
So under the second part of the best evidence rule, as articulated in Shozer, the people, as the proponent of this secondary evidence, bore a, quote, heavy burden of establishing that the witnesses they were proffering were correctly reflecting the original video. And I submit that, we get into in our briefs about all of the discrepancies between the witnesses.
There was full cross-examination in this case. They were witnesses in the case. They got to be cross-examined. Any discrepancies, to the extent they existed, could be brought out. The jury could consider them, and the jury could evaluate all of that.
So first, I would submit that there were such significant discrepancies that...
If you had 7 people watching the occurrence live, and then they came in to testify, there'd be discrepancies between what they had to say also.
That's absolutely correct, and that's what the trial court reasoned as well. That's not enough under the best evidence rule. Under the best evidence rule, if you don't have the original writing, you bear, as I was just saying, the heavy foundational burden of establishing to the court's satisfaction. This is all a quote from Shozer, to the court's satisfaction, not the jury's, that the people who are testifying are accurately and reliably reflecting the original writing. And I would submit that there's really no way for people talking a year and a half later to accurately reflect the blow-by-blow of an assault, what the people call a mutual fight.
But again, people do that all the time when they're have direct testimony. They come a year and a half later and they testify blow by blow about what they saw.
But the problem is they're testifying not about what they saw in quote unquote real life, but what they saw on a video. And nobody testified here. It isn't notable that nobody testified here that the video, that they saw the video and it accurately reflected what happened to them. That's typically how a video is authenticated. That's the number one way. It happens all the time in courts across the state.
Here we weren't authenticating a video.
Correct, but an even stricter authentication requirement applies at the second prong of the best evidence rule when you don't have the best evidence.
Didn't all 7 witnesses agree on the core matter, which was there were 2 women engaged in a fight, the victim ended up on the ground, and the defendant continued to punch the victim once the victim was on the ground?
They did not agree on that, on the specifics of that. I think it's there's a case cited in our reply from an armed forces appeals court that talks about the Jimenez case, which more or less is exactly the same as ours from the Bronx County Supreme Court. The dynamics of an assault that's what the phrase that the armed forces case uses. You cannot reliably summarize the dynamics of an assault based on 1 or maybe 2 viewings of a surveillance video. And it does bear emphasis that the surveillance video in this case was not very high quality. The cameras were replaced a couple months after because they were so blurry and so unclear. This is, and I want to come back to people.
Nobody testified that they were so blurry or so unclear. And their testimony did not reflect that. I mean, maybe they did replace them because cameras are getting better, but I didn't see anybody say that specifically, that it was so unclear and so blurry. They all seemed to be able to testify, that they were able to see it and what they saw.
Well, Your Honor, Luis Caraballo, the superintendent, one of the people who had the password, the only one who had the password, presumably fairly familiar with the system, said the video quality was, quote, not good. That's at page 29 of his hearing testimony. Devon Kelly, the property manager, testified that it was, quote, okay, and agreed that
There are discrepancies as to the quality of the video also.
There are discrepancies about everything, respectfully. The only agreement is that there was a fight and that the complainant was injured.
And we're not really interested in the video per se. We're only interested in what the video reflected as having taken place. So
correct.
Where does the authentication of the video, the quality of the video, really become the operative question?
Your Honor, I do think it's important that these 7 people who said, I saw the video, did not witness the fight, so we're unable to say this video accurately reflected reality. There was no connection in that regard between the video and reality. I realize that we
don't really need that because we're not interested in the video as such.
But the people were trying to prove the contents of the video, and they don't say otherwise on appeal. They couldn't say otherwise. All 7 of these witnesses were testifying as to the contents of an original writing, this video. And under People v. Cyrus from this court, People v. Manahar from the 2nd Department, People v. Jackson from the 4th Department, this sort of People v. Drager just last year from the 4th Department, all of those cases squarely hold that merely summarizing what you earlier saw in a surveillance video is inadmissible under the best evidence rule.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Peter Rienzi for the people. Your Honors, defendant's conviction should be affirmed. The trial court's decision to allow the witnesses' testimony about their observations of the video was a proper exercise of the court's discretion under the circumstances of this case.
Counsel, in this particular case, didn't the trial court then issue a sanction in the form of a permissive adverse inference for the jury to consider? So the judge went one step further after the cross-examination of these witnesses to offer an adverse witness. So if you did not, if you did not believe this or you're concerned about this, then you don't have to deem it true. So that was another step the judge took, correct?
Yes, it was, Your Honor, and that remedied any prejudice that the defendant suffered from the admission of that testimony. As argued in our brief, this decision was proper under the best evidence rule. It was clear that the people had explained the loss of the video, that the video's unavailability was not procured by the people in bad faith, and that the derivative proof, meaning the testimony, recited in the words of Shozer substantially and with reasonable accuracy all the video's contents. I would note the video, as Your Honor, Justice Hager was saying, all of the witnesses testified that they were able to make out the differences between people, that they were able to see what happened on the video. Nobody said they couldn't see who hit who or couldn't see what happened. And they did all agree on significant portions of the incident, as Your Honor stated. The physical fight that occurred between the two women, the fact that Ms. Scott fell to the ground and that defendant continued to strike her, either punching or kicking. 6 of the 7 video witnesses did testify to that.
Under Shozer, to what extent can there be asymmetry or departures where there's more than one secondary evidence witness? To what extent can we condone departures in their testimony?
Your Honor, I would say that in this case, because Shozer, of course, says substantially and with reasonable accuracy, it can't be the standard that if the witnesses come in and don't give a frame-by-frame retelling of it, that is inadmissible. That would be inconsistent with this court's decision in Tanner, with the 4th Department's decision in Jackson in 2020, which is cited in defendants' briefs. In other words, in those cases, there is discussion. Video is allowed. In Jackson, it's on the people's case. In Tanner, it's after the defense opens the door. But in other words, it's not. Those courts don't lay out that it has to be this level of detail where it's frame by frame, and that's consistent with, as we cite in our brief, Prince Richardson on evidence, which I think is cited in Shozer itself, saying that it doesn't have to be, if it were a writing, it doesn't have to be word for word.
What about your friend's reliance on People versus Cyrus?
Your Honor, Cyrus, we argue in the brief that Cyrus does not stand for the proposition that missing video evidence is never allowed. Obviously, this court decided Tanner after that. In addition, Cyrus can be distinguished in ways that favor this case. Cyrus, the decision itself, this court's decision, noted that it was, first of all, the court said it was likely inadmissible, not that it was certainly inadmissible. Second, the court decision noted that the video was of poor quality. My adversary makes a different argument, obviously, where we're making different arguments, but my adversary discusses in their brief, in the reply brief, that in Cyrus, it's about a very quick instance, in that case had to do with officers viewing this lost video for a sign of a weapon. I would argue here, the broad strokes of what happened here, the fact that there was a fight, the fact that defendant fell down, the victim fell down, hit the ground, and defendant continued to strike her. All this, which was also consistent with the victim's non-video testimony. All that, in other words, because it was longer than the split second that this weapon may have appeared in the poor quality video of Cyrus, we would submit that it's, in other words, that distinction favors this case here in that the witnesses were able to give substantially and reasonably accurate testimony about it. If I could just briefly address the other issues in our briefs, the evidence here was clearly legally sufficient and supported by the weight of the evidence, and the people did disprove the defendant's justification defense beyond a reasonable doubt. If there are any further questions, I'm happy to answer them. Otherwise, we ask that you affirm.
Thank you.
First, in response,
You did talk about a lot of your cases, but you did not talk about People versus Tanner, which obviously the people did talk about a lot. Why isn't People versus Tanner dispositive of this case? Because we did clearly hold in that case that there are circumstances we're going to allow in this kind of testimony that it doesn't per se violate the best evidence rule.
right, so there
Why is that
there are
case
three important distinctions between this case and Tanner. The first is that, as my adversary just said, that was an opening the door case. That in that case, the security guard was only offered after the defense tried to create an improper and inaccurate impression that the surveillance video might have been helpful to the defense. And then the security guard comes in and says, well, actually, it was lost, but I did view it, and in broad strokes, it was consistent with what the people's witnesses are saying. So it's an opening the door case. It doesn't say anything about 7 witnesses coming in on the people's own case. The second difference is that that witness, that sole witness in Tanner, was the security guard who was very, very familiar with the store surveillance video, and that's also the same as Jackson. That's what the people emphasized in their respondents' brief in Tanner. This is a person who we can trust, who watches security footage all the time, and would
It's a
have
factual analysis.
would
You're
reason-
arguing the facts, you don't support it.
absolutely. But,
Thank you.
but
Counsel, thank you.
thank you.
Papis versus B&G Holding.
Good afternoon, Your Honors. Alan Ahern for the appellants. Your Honors, there's two fundamentally...
So, under the terms of the partnership agreement, it's clear from paragraphs 2A and 2B that if a person is alive, they can't just dispose of their interest.
I'm sorry, Your Honor, I didn't hear the first part of your question.
Under paragraphs 2A and 2B of the partnership agreement, it's clear that if a person is alive, if a partner is alive, that partner could not dispose of his or her partnership interest. Under paragraph 4A, if a person passes on, it's clear that there's an intention that that deceased partner's interest be tendered to the surviving partner. So how could you, upon the death, how does the will push aside this clear contractual agreement that what the will provides is just not to happen?
Your Honor, if I may, I think there's perhaps some semantics there. It's not so much clear that the agreement says that the partner, the deceased estate must tender. The estate must tender, but that would be only if the estate has any possession. And under the EPTL, specific bequests pass outside of the estate.
It says 4A says the death of a shareholder or partner shall constitute an offer of the personal representative of such deceased shareholder or partner's estate to sell all of his shares or partnership interest held by the estate.
That's correct. And the estate holds nothing because specific bequests title vests immediately in the specific devisee. That's EPTL.
How can the will give the testator the right to carry out a transaction which the partnership agreement denied him?
It did not, Your Honor. If you look, paragraph 2A at page 70 of the record, that says that it's, first of all, it's under the heading of lifetime transfers.
Right.
Lifetime.
So you've got a provision dealing with lifetime, and you've got a provision dealing with death. It looks like that this agreement meant to cover all eventualities.
I would disagree respectfully, Your Honor. The paragraph 2A, inter vivus transactions only, lifetime transactions. And so if you look at all of the provisions in Article 2, they contemplate that that if there was...
No question about that.
Right.
But then you get to 4A, and that deals with the situation where it's not lifetime.
Okay. So if the court agrees that 2A does not necessarily apply to the specific bequest, because the specific bequest is not a disposition or an encumbrance or some other...
Well, it's clear you have a solid argument to say that 2A doesn't apply to situations of death.
Okay. That's great, because the lower court disagreed with that.
It doesn't get you home, though.
But, Your Honor, if you look, and this is well documented in the brief, specific bequests under the EPTL pass outside of the estate. The language at paragraph 4 says that the estate, the representative can offer only that
Would
which the
someone
estate
make a
holds.
specific bequest of something which he doesn't have a right to bequeath?
He absolutely has the right to bequeath it if there is no prohibition against making testamentary bequests, because the only limiting provision anywhere in the agreement is paragraph 2A.
What
Paragraph,
about 4A? Why isn't that a limiting provision?
because
Paragraph 4A, though, I mean, you're right, paragraph 2 talks about lifetime, but as my colleague just stated, paragraph 4 talks about death. The death of a shareholder shall constitute an offer. Why shouldn't that be interpreted as a specific agreement by the partners that if one of the partners dies, this is the procedure for how that partnership interest should be handled as opposed to a will?
this is the procedure for partnership interests that pass to estates. The estate, as
I mean,
a
if
matter
there
of
was no
law,
will,
But where does
then
it-
that would have
yeah.
been okay.
Where
if
does
there
it
was no
say
will,
that?
if there was no specific bequest, then by the laws of intestacy, that the partnership interest would have passed to the estate.
So you're saying the bequest, the specific, what he provided for in the will, sort of trumped the paragraph 4A, and by the time that he no longer had that interest to pass through paragraph 4A.
Not
That's
so
what
much a
you're saying?
matter of trumping, Your Honor. They are two separate things.
But
The
where in
estate,
4A does it make a distinction? You're saying there's a distinction between when something passes by a will versus when the representative of the estate has to do something. But looking at paragraph 4A, where does it show an intent by the two partners who agree to this provision that they're going to treat those two different situations differently? So since it solely refers to this is what happens when a shareholder dies, it doesn't say this is what happens when a shareholder dies and there's a will versus this is what happens when a shareholder dies when there's not a will. So where from this paragraph can you get that different intent?
Your Honor, if the agreement is silent as to specific bequests, that doesn't mean that we can infer or just assume anything
But
about
it
the
says the
agreement.
death of a shareholder, so it says if a shareholder dies, this is what happens in all situations.
No. Respectfully, Your Honor, it says if a shareholder or a partner dies, the representative is deemed to be making an offer to the surviving partner of only those assets or partnership interests that are held by the estate. It specifically says partnership interests that are held by the estate.
Aren't we essentially reading paragraph 16 out of this document then?
Paragraph 16.
This agreement shall be binding upon and inured to the benefit of the respective heirs,
Yes.
executors, administrators, successors, and assets.
Yes, Your Honor, that only that which was binding in the first place inures to the benefit of the heirs. There is nothing that directs first of all, there's nothing that limits specific bequests. Paragraph 2A applies to lifetime only. There's nowhere in the agreement under the statute of frauds, EPTL 13-2.1, anything that satisfies the statute of frauds to limit testamentary bequests. Nothing anywhere in the agreement, and there's no direction that the deceased partner had to transfer his interests other than by specific bequest to his estate. So he was free to make his will. There was nothing in the agreement that prevents him from making the will. He made a will. It was a specific bequest, and as a matter of law, under the EPTL, his interests passed outside of the estate, which means that paragraph 16, only that which was binding in the first place would inure to the benefit of the heirs, executors, or assigns.
Thank you. You have time to rebuttal.
Thank you.
Good afternoon, Your Honors. My name is Jack Piana for the respondents B&G Holdings and Jean Leogrand. May it please the Court. As Your Honors have rightfully identified, paragraph 4A of the partnership agreement speaks to the contingency of the death of either of the partners.
So what about the language that was pointed out, though, in 4A, which it talks about the partner's estate to sell all of his shares of partnership interests held by the estate? What about the argument that if it passes by the will, then it's not held by the estate?
I understand that, Your Honor. And I guess the operative language there, it relates to the personal representative or the executor or executrix. The issue is who's going to sell
What
these.
does it mean passing outside of the estate? I know your colleague speaks about it's passing outside of the estate. How does the asset transfer when it transfers outside of the estate for the specific bequest in the will, whose hands does it go through? I mean, it doesn't just automatically, the will says it's bequeathed to someone. It doesn't automatically just become that person's property. What happens?
You made the argument for me, Your Honor. That is one of the principal issues here. It's that this isn't such as a...
So personal representative is going to have to turn it over to whoever the will says is supposed to get that specific bequest. It does come into the hands, so to speak, of the personal representative.
That's correct, yes, Your Honor. This isn't something like a life insurance policy or a jointly held
bank account.
Right, thank you, where by operation of law, it automatically transfers through the bank. Here, there has to be a sale consummated between the personal representative and B&G Holdings, the representative of B&G Holdings. That necessarily involves somebody, and there is no passing otherwise. Just in terms of 2A, the language that is cited by the lower court and the language that is stated in the agreement itself begins with no shareholder shall transfer pledge and the like. I believe counsel is relying almost exclusively on the language of the section heading on top of that, but the paragraph or the provision itself speaks nothing about this prohibition only applying to lifetime transfers.
It says lifetime transfers in the heading.
It does.
So, I mean, your better argument is that 4 comes into play. Right?
4 does come into
You have
play.
to read 2 and 4 together, I would think would be.
That is correct, Your Honor.
And this agreement, I don't believe, included a provision that the headings don't mean anything.
It does not, Your Honor.
It's
No.
not in that agreement.
But the provision of 2A is also set forth in provision 9B, where it discusses the legends and such that would be applicable to a share, and then it also reflects that the partnership agreement would reflect that no transfers would be made outside the provisions of this agreement. There is no discussion or no language in the provisions of this agreement that allow for the partners to transfer their partnership interest to another party. And I think that it's important here that this whole issue relates to the methodology that is required through the partnership agreement to determine the value of the late Mr. Egan's partnership interest. And that's what's at issue here. Here, we don't have any indication that there is a, or rather, my colleague is arguing that the partnership interest passed to Mr. Papis prior to the death or at the death, or that the death, as Your Honor aptly put, that the specific request trumped the election or the automatic trigger of the automatic trigger to sell at the time of Mr. Egan's death, and that's just not reflected in the case law. It's just not reflected in the partnership agreement. There was an automatic offer to sell that was set forth. It called for the contingency of death. The partners had very clear intent to allot or put down their agreement with relation to either of the partners' deaths, and Mr. Leogrand satisfied all of his obligations requisite to compel Mr. Papis to sell the interest back to Mr. Leogrand, and I'm asking that this court affirms the lower court decision.
Thank you.
Your Honors, there is no automatic trigger. There's nothing like that anywhere in the agreement. And Your Honor, if you look at page 16 and 17 of my brief, there's a lot of case law in there that says, in fact, the quote I always liked from In re Williams, 1937, law, like nature, abhors a vacuum. It specifically says that specific bequest, title in property that is specifically devised, vests immediately at death. And the fiduciary does not have the obligation or the rights to take possession, have no possession of that property under EPTL 11-1.1b5, can only take possession of that property if the estate has debts that must be satisfied.
How would these shares or this partnership interest, how would it mechanically actually get transferred? It doesn't just happen automatically. What steps would have to take? It has to go through the personal representative, does it not? Actually And if your position prevailed, it would be what would happen. But it has to be the personal representative turning it over to this prospective purchaser or heir.
Having legal title and managing the logistics of a closing are two totally separate things. The specific devisee, as a matter of law, under the EPTL, has legal title immediately.
It's going to come into the personal representative's hands, even if just to be transferred right out to some other entity.
It does not. The title exists, it invested immediately by law in the specific devisee. The personal representative, if anything, would have the obligation to show up as a fiduciary to execute documents, to simply say that we have nothing at a closing, but the partnership itself needs to transfer. And really what needs to happen, because this is about real estate, there's a few different buildings in the Bronx that are at issue in this partnership. They need to be properly appraised, and they need to be sold or bought out.
Thank you very much.
Thank you, Your Honor.
Malerba versus New York City Transit Authority.
May it please the court, good afternoon. My name is Patrick Caruana. I represent the appellants and defendants in the lower court, New York City Transit Authority and Metropolitan Transportation Authority. We are asking this court to reverse the lower court and strike the plaintiff's late supplemental bill of particulars that adds new claims and new code violations that weren't pled in the original complaint and weren't pled in the original bill of particulars. We are also asking the court to reverse the lower court and grant the transit defendants summary judgment for contractual indemnity against a co-defendant, EA Technologies and Petrocelli joint venture, and I'll refer to them as a joint venture. The plaintiff here.
Let's go, there's two separate issues. Let's go
Two
quickly
separate
to the
issues.
bill of particulars first. There was a request made for the first time in opposition to treat these as an amended bill of particulars. What is your position as to that?
Oh, and the amended bill of particulars first.
As opposed to a supplemental bill?
Correct. For the amended bill of particulars, that argument wasn't made in the lower court. It actually was made for the first time 3 years later. After
In the opposition brief?
The opposition, in the reply brief. It wasn't made in opposition in the lower court. We weren't able to develop the facts of actually when that was actually served because it didn't matter in the lower court. So the court shouldn't consider it.
So is your argument that this court should not consider that argument on appeal because it should have been raised below?
Because excuse me.
Because it should have been raised below, it
Correct.
should be raised for the first time. on
And we could have addressed the issue whether there was another amended bill of particulars before this one, because CPLR 3042 only allows one pre-notive issue. And then we could have scrutinized if that supplemental bill of particulars was actually served before the note of issue, because there's no affidavit of service in there. There's no, it just dated one day before the note of issue was actually
Do you
e-filed.
think it's something that could be resolved on the record before this court?
No,
Based on what you just said?
based on what I just said.
Let me ask you a quick question about the indemnification issue.
Sure.
This is a somewhat unusual to me provision because it does clearly seem to be indemnifying at least one of the defendants here for its own negligence. Why isn't that prohibited by the GOL, at least to the extent that it's indemnification for one's own negligence?
Because this is not a type of contract that falls under the GOL.
Why not?
Because it's not it's not for construction, and it doesn't affect real property. And I cite the case. It's a fire extinguisher. It's a tank. You know, it's a,
Right, but if you look at the actual contract itself, rather than what exactly this person was doing, this plaintiff was doing, it's a much broader contract in terms of what it encompasses.
but it doesn't involve construction, and it involves the service of fire protection systems and different aspects of that. Periodic servicing. If a tank needs a refill, they'll take it out. They'll remove it. The JV will remove it and then take it out to be refilled. So it
Do you have
doesn't.
any argument other than the inapplicability of the GOL as to why we shouldn't enforce the indemnification for its own negligence clause.
Well, it's undisputed that the negligence, that the contractual indemnity clause was triggered. So that's undisputed.
So what happens if we disagree with you about the applicability of the GOL? Then what happens?
Then,
what
well,
do we do?
Well, it's conditional contractual indemnity.
That's to both defendants.
It's both defendants, and there is a
No
savings.
matter what you're arguing, because there's no issue that at least there's some negligence, not 100% negligence, that worst case scenario for you, it's conditional as to both defendants. Best case scenario, you get complete indemnification without the conditional part as to one of the defendants.
Correct, Your Honor. Correct, Your Honor. And we, at the very least, conditional, because there's no dispute that this happened. It triggers happened pursuant to the JV's work under this contract, and it's a broad indemnity agreement, and it's triggered. There's no dispute about that.
Your position is the only real issue is whether GOL applies to prevent the conditional part.
No, for the full indemnity against the MTA.
Right, as opposed to conditional.
As opposed to conditional. And that matters because we claim we're free from negligence, but we're also, if we're found free from negligence, it doesn't end that we're also entitled to attorney's fees under that
Let me ask you
contract.
something, because this GOL, I mean, the argument you were making sounded more like a labor law type of argument about what the scope is, labor law 240, what it applies, but I'm looking at the language of General Obligations Law 5322, and it says it applies to contracts relative to the construction, alteration, repair, or maintenance of a building. So it's not just construction or alteration. If it's a overall repair maintenance agreement, it would be covered under 5322. And here, it does seem to be a contract to inspect, install, remove, and convert complete fire suppression systems, as well as provide remedial maintenance. Why wouldn't that come under the terms of the GOL provision?
Because you're not maintaining a building. You're maintaining a fire extinguishing tank. You're not maintaining the entire building. This was taken off-site.
Building, structure, appurtenances, and appliances. It's very broad. It's not 240, which is, 240, there's a lot of cases around 240 and what 240 does and doesn't apply to, but this is not 240. It's a very different provision.
Well, I cite to
Why isn't this appurtenances?
Because I said to my brief, and I point to Pierre versus Crown Fire Protection, which involves a fire extinguishing system, that these are services of a piece of equipment.
Okay.
And Your Honor, one point I'd like to point out with.
No, you could do that on rebuttal.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Matthew Corcoran for the defendant respondent joint venture entities. Your Honor, I believe you hit the nail on the head when you cited the GOL language. It applies to the construction, maintenance, alteration, repair of buildings, appliances, or appurtenances.
Let me ask you a question first. Let's say GOL does apply. Is there any dispute that both of these defendants would, at a minimum, be entitled to a conditional summary judgment on their indemnification claim?
There is a dispute because if the GOL applies and the clause is in violation, they cannot get direct or conditional.
Clause.
I'm sorry?
It's got a savings clause.
But it still directly requires the indemnification of the MTA.
But don't we have a legion of cases that say as long as there's a savings clause, you enforce it to the extent it's enforceable? It doesn't invalidate the agreement.
Well, but there's no other reason for these third-party beneficiaries to be indemnified other than the language in the clause that says we are to indemnify them for their own negligence. There's no fullest extent of the law that you can indemnify somebody for their own negligence if the contract
Right, but let's say it has a savings clause, so you take out the part that they can be indemnified for their own negligence. What's left is that they can be indemnified to the extent that this accident occurred not because of their negligence. And clearly, there's some evidence in this case that they are in no way 100% responsible. So why, under those circumstances, wouldn't they be entitled to, at a minimum, conditional?
Well, if there's any portion of the indemnification clause that's violative of the GOL, then the entire clause is null and void, and that's actually from this department.
I guess I'm not understanding yours.
I'm sorry, I was just trying to respond to your question, I'm sorry. Even if there's a savings clause, there's still a requirement that we indemnify them for their own negligence. And this department, the first department just last year decided the case, Vasquez versus Manhattan College, and Justice Mendez, Justice Higgett, and Justice Kaepernick, you were all on that panel, and it says, if there's any portion of an indemnification clause that violates the GOL, the entire agreement is null and void, and the indemnity cannot get indemnification under any part of it. And I would still argue that the clause that requires us, the portion of the clause that would require us to indemnify the MTA for their own negligence is in itself in violation of the GOL, irrespective of a savings clause.
Okay, let me go for a minute to the indemnification, the bill of particulars issue. Why, under the circumstances of this case, should we address your argument made for the first time in appeal that this is really an amendment, not a supplemental bill of particulars?
Well, Your Honor, that's not my argument. That would be for plaintiff.
Oh, I'm sorry, I'm mixing up the cases. You're JV, right?
If they weren't negligent, why wouldn't, and there's a savings clause, why wouldn't they have to then provide indemnification?
Well, there's, on that
I mean,
point,
if they're negligent, okay, so you can't indemnify them for their own negligence, but if they're not, why wouldn't they get, and that's two-way fact-finding.
well, that would still require a finding of them being free from negligence, and they're still in the case. The court explicitly denied their motion to get out of the case on negligence, so there's very clearly still a question of fact, which is why, as far as that question, it would be premature to award them
So
indemnification,
why wouldn't they be
assuming the
entitled
clause
to
is okay.
conditional indemnification at this point, dependent upon whether or not they were negligent?
Well, because I still think there's a question as to whether or not the clause is in violation of the GOL, and if it does violate the GOL, then no type of indemnification, including conditional, is appropriate.
So you're saying there's no such thing as a savings clause?
Well, I'm saying the savings, I think that the plain language is too explicit in this clause because it directly says we indemnify them for their own negligence. It doesn't say.
Can you give me the set? You're saying there are cases that specifically say if the clause violates the GOL, the savings clause has zero effect and cannot save it, and as a matter of law, and that's it?
Well, I'm saying if any part of the clause violates the GOL, the entire clause is void.
Okay, and what case say that?
That would be Vasquez versus Manhattan College. I can give you the site. That's 223 AD 3D 601. It's a First Department case from just last year, 2024.
I'm sorry, what was the site again?
Vasquez versus Manhattan College.
Okay, thank you.
Thank you, Your Honors.
It was 601?
So yes, 223 AD 3D 601.
Good afternoon, Meredith Abrams of Whites and Luxembourg for the plaintiff respondent. I'll start with the question you were going to ask my colleague here about whether this argument was raised below. First, I would say that it was. In our papers below, we did argue that this...
I'm sorry, if you could speak up a little bit.
I'm a little shorter. In the papers below, we did argue that this bill of particulars was acceptable because it was filed one day prior to the note of issue. While we did not use the correct language of amended bill of particulars versus supplemental bill of particulars, the heart of the argument was there. Additionally, while the procedural posture of this case was that Judge Adams below did not address the bill of particulars in her first decision on these issues and then addressed it later in a motion to reconsider. And on papers for that motion, we did cite the 3042 statute, and we did specifically argue that this bill of particulars was an amended bill of particulars under 3042, which led Judge Adams.
Why wasn't there any discussion below then of any of the statute of limitations issues, which would have come up if there was an amended bill of particulars?
Well, Judge Adams did rule that this bill of particulars did not add any new claims when she
Not what?
did not add any new claims. She wrote that in personal injury matters such as the instant action, supplemental, she used them interchangeably as well, bills of particulars may be served without leave of the court at any time, but not less than 30 days prior to trial, provided that no new cause of action may be alleged or injury claimed. So she considered it a supplemental bill of particulars and said that no new cause of action and no new injury was claimed, which is my next point here.
Are you arguing that?
That no new cause of action
is asserted in these bill of particulars?
Yes, I am, Judge.
How are you arguing that?
So The cases cited by my opponent are cases in which an entirely new claim was added. So plaintiffs brought actions for common law negligence and then added a statutory labor law claim, things like that.
What about the claim, you used the word conspiracy in your bill of particulars, right?
Yes.
You say there is a conspiracy. Isn't that a new cause of action?
That language was being used colloquially, Judge. What we're claiming is that the New York City Transit Authority and MTA were negligent in the ways in which they serviced and managed this fire suppression system. The fact that that negligence resulted not just from what you might think of as garden variety, failure to supervise, failure to hire, general negligence, but sort of a more complicated sort of negligence in which there may have been corruption, there may have been bribery, this contract.
You were saying that they conspired to get people that weren't as qualified to do the work. I mean, and it was a specific kind of claim. Should defend, and then the next day you filed the note of issue. So where does that leave the defendants?
We're claiming that the defendant was negligent in giving this contract to this company which hired our plaintiff because they were not licensed, they were not trained. That is the same common law.
You have that already in your original.
Exactly. It's the same common law negligence claim.
So what are you saying right now today that this document is? Is it an amended bill of particulars or a supplemental?
We would argue that it's an amended bill of particulars pursuant to CPLR 3042, but I would add that it is a distinction without a difference in this case because we are not adding a new claim or a new injury. And I would point to Spiegel versus Gingrich, in which, you know, the court noted that leave to amend a bill of particulars should be freely granted where there is no prejudice and surprise, and add that the depositions that gave rise to this evidence were taken in 2013, 2014.
Well, see, here's where the nuance is important here. If it's an amended, if that in fact is what it is, then it becomes important when it was interposed. Because if it was interposed before the filing of the note, then you get the benefit of doing it by leave. If it hasn't been established that it was interposed before the filing of the note, and I guess to take it a step further, that you also have to establish this was the first amended bill of particulars, right? Because you only get to do it once as of course. If you don't show those two things, now the amendment has to be done with leave, and then it becomes a discretionary call for the judge where he or she can factor in the delay, prejudice, right?
Yes, Judge, and if I could go over my time, Judge Adams did consider that and ruled that it was acceptable, and that because it added no new claims and because there was no prejudice, it was an acceptable bill of particulars.
But the problem is we don't have that before us, do we? We have her original order.
No, Judge.
Which does something much different and doesn't grasp these particular issues and reflect findings.
That's correct. The judge's original order did not, but this court could take judicial notice of what's on the Supreme Court docket. Additionally,
Your time's up. Thank you very much.
Thank you.
I'm sorry, do you want to have 1 minute to state what you want to state? And you did put in a brief, so go ahead.
Thank you, Your Honor. May it please the court. Alyssa Katz for third-party defendant, Amaron respondent. While we take no position on the legal arguments before this court, and Amaron is not the subject of these legal arguments, I would just like to address, which we've done in detail in our brief, that the allegation about Amaron's being qualified, is in dispute. It's a finding of fact that has not yet been determined. So those representations made by counsel we respectfully disagree with and rest on the citations we make to the record in the brief. Thank you.
With respect to the contractual indemnity.
What do you think of Vasquez? What do you think Vasquez says?
Well, the Vasquez, the contract at issue, and I think it was not even a contract, I think it was a purchase order. The footnote has the indemnity language, and there's no savings clause in that indemnity language.
So it's completely distinguishable.
It is, and it actually
This one definitely does have a savings.
This one definitely has the savings clause. And when I say savings clause, so we're on the same page, it says to the extent, to the fullest extent permitted by law.
Right.
So, and by the way, Vasquez is not even in their papers. It wasn't even.
Because there was no analysis in Vasquez of the savings clause.
Correct. And with regards to, this is with the supplemental de facto amendment, however you want to call it, it certainly is alleging new claims. Their initial claims was that this tank was defective. and that somehow the New York City Transit Authority, MTA, who undisputed did no work on this, was negligence in maintaining it and repairing it. These new
Did Justice Adams issue a subsequent order, though, on this?
There was a motion to re-argue, and I actually drafted the motions, and there was no, this was the first time this, on the reply brief, was the first time there was ever made an argument that it's in fact an amended, an amended bill of particulars. I did a motion to re-argue, and it was denied on this order that's before the court now. But obviously it was a motion to re-argue, and it's not in the record now. And like I said, I drafted the motion and the reply, and there was no argument that this was now a supplemental BP. The first time I heard it was an amended BP was when I got the reply brief, or respondents' briefs. And again, these are new claims. Why else would you do this?
Thank you.
Thank you.